In this video, we are exploring some of the basics of employment law. And so the first thing we're going to look at is employment at will. Most states are employment at will states, and basically that means that the employer has the right to terminate your employment at any time for any reason. Now, there are some exceptions to the employment at will doctrine. Some of those exceptions are based in contract law. For instance, if you are employed under an express or implied contract, then the employer would have to honor the terms of that contract or else be held in breach. Some of the exceptions are based in tort law. For instance, if there was a wrongful termination or abusive discharge, you would have a basis in tort law to sue the employer for terminating your employment. And then some exceptions are based in public policy. For instance, whistleblowers, if you report to the government something that your company is doing that is not legal, you can have whistleblower protection, and so they can't terminate you for reporting them. Likewise, they can't terminate you for serving on a jury or for participating in lawful union activities. Some other laws that can come into play in the employment context are wage and hour laws. Two of the most well-known are the Fair Labor Standards Act, or FLSA, and the Family Medical Leave Act, the FMLA. The Fair Labor Standards Act prohibits child labor. It also addresses minimum wage and overtime requirements. It essentially breaks employees into two categories, exempt and non-exempt. If you're an exempt employee, that means that you don't have to be paid extra for overtime, and usually this applies to salaried employees and those in management. But if you are a non-exempt employee, usually an hourly worker, then the employer is required to pay time and a half if you work more than 40 hours in a given week. The Family Medical Leave Act is a law that applies to businesses with 50 or more employees, and it requires those employers to provide up to 12 weeks of unpaid leave per 12-month period for family or medical reasons. So this could be either the employee has some health condition that prevents them from working. It could be a close family member like a child or a parent who needs around-the-clock care, and the employee would be permitted to take those 12 weeks to go and care for that family member. It also applies with the birth of a child or the adoption of a child. You can take 12 weeks to be home and to care for that child. The employer may allow you to use paid leave during your FMLA leave. So for instance, if you have sick leave or sick time built up, you can use that concurrent with your FMLA leave, and that way the leave is not unpaid. While you are on FMLA leave, your job is protected, and so you have a right to return to that employer in the same job or one that is similar. The exception there is for key employees. If you are a key employee who is very important to the organization, then you don't have that same job protection. The Occupational Safety and Health Act, or OSHA, and we're getting now into health, safety, and income laws. OSHA sets safety standards in the workplace, and there are OSHA inspectors that will come around and inspect factories and businesses and make sure that they're complying with safety regulation. So businesses are subject to that inspection, and businesses can be fined or face other penalties if they do not comply with those safety regulations. If an employee notices a violation of a safety regulation, that employee can file a complaint. Workers' compensation laws are there to provide an administrative process for compensating employees for work-related injuries. Once the benefits are accepted, the employee is precluded from suing the company in court. So it's designed to provide a quicker and faster remedy for an injured employee. The one requirement there is that the injury does have to be work-related within the scope of employment. Income security laws, things that come into play here are Social Security and Medicare. Those deductions are taken directly out of your paycheck before you even see the money, and that money is used to fund Social Security and Medicare benefits for those who are retired. And so the money is taken from current workers to provide for those older workers who are already receiving Social Security and Medicare. Unemployment insurance. All employers pay into an unemployment insurance fund, and then if they were to, say, downsize and let you go without a justification, you hadn't done anything wrong, they just let you go, then you would have a right to file a claim for unemployment insurance, and you would receive some payments out of that unemployment insurance fund for a period of time. Another income security law is COBRA, and that is a law that allows workers to continue for a limited period of time their health insurance coverage that they were receiving from their employer. But the catch is, for COBRA, you have to pay the entire insurance premium. So the employer is no longer paying a portion of the insurance premium for you. Immigration law, two things to point out here. First, I-9 verification. Employers are supposed to verify that the person they are hiring can legally work in the United States. And so if an employer hires someone who is here illegally, the employer can be fined up to thousands of dollars. The visa program is a program that allows employers to request a visa for a particular employee, and if approved, the visa program allows that employee to come to the United States and work for that employer for a period of time. Students also can obtain visas in order to come study in the United States. Moving on now to employment discrimination laws. The 1964 Civil Rights Act prohibited employment discrimination on the basis of race, national origin, color, gender, or religion. It also created the EEOC, or Equal Employment Opportunity Commission. If you feel that you have been a victim of discrimination in employment, you can file a claim with the EEOC, and they have an administrative process that they will go through and explore that claim with you. In 1991, the Civil Rights Act was updated, and the law shifted the burden of proof from the employee to the employers. It requires the employers to show that their practices were not discriminatory, and it also allows for recovery of punitive damages. So by shifting that burden of proof, it makes it easier for the plaintiff in a civil rights case to make their discrimination case. Disparate treatment, and this applies, disparate treatment and disparate impact apply to any type of discrimination. But disparate treatment occurs where there is intentional discrimination against a protected class. Whereas disparate impact occurs where the company's practices or procedures are not discriminatory on their face. I mean, if you read the policy, it wouldn't appear to be discriminatory, but the way they apply the policy has a discriminatory effect. So they have essentially a neutral policy, but it's being applied in a discriminatory manner. That is disparate impact. Constructive discharge, that occurs when there is termination of employment brought about by making intolerable working conditions, such that the employee feels that he or she is compelled to leave. I want to say a few words now about sexual harassment. There are two types of sexual harassment. The first is quid pro quo, which means something in exchange for something else. And this type of harassment occurs when sexual favors are demanded in return for job opportunities, promotions, and things like that. The second type of sexual harassment is the hostile work environment. And this occurs when there's a pattern of sexually offensive conduct in the workplace that hinders the employee's ability to do his or her job. And this is more than just an isolated incident, it's an ongoing pattern of behavior. What if it's a supervisor that is doing the harassing? If it's a supervisor, the employer may be able to limit or avoid liability if it exercised reasonable care to prevent and correct the behavior, and the complainant failed to take advantage of preventative or corrective opportunities provided. But what if it's harassment by a coworker? Then the employer may be liable if it knew or should have known of the behavior but did not take action to correct it. The Age Discrimination in Employment Act is a federal law. It prohibits age discrimination of people over age 40. It prohibits a mandatory retirement age for non-managerial workers, and it only applies to employers with 20 or more employees. The Americans with Disabilities Act states that if a disabled but otherwise qualified applicant can perform job duties with a reasonable accommodation, then the employer must make that accommodation, unless it would cause an undue hardship on the employer. Now, this is not creating a hiring preference for those with disabilities. It's just saying that you can't refuse to hire someone because of their disability. Instead of that, you should accommodate for that disability. Some defenses that employers might raise if they are sued for discrimination: they may argue that their decision was based on seniority or merit. The employer may allege the defense of business necessity, just showing that the employment practice that discriminates against members of a protected class is in fact related to job performance. And then the employer may also raise the defense of a bona fide occupational qualification, and that is a identifiable characteristic reasonably necessary to the normal operation of a particular business. And so, for instance, in a women's clothing store, it would be a bona fide occupational qualification that they only hire women, especially if it were a store like a Victoria's Secret or something like that. So that is a quick overview of employment law.